Okay, we'll jump into it, hey? So hi everybody. Welcome to our webinar for Privacy Week. Happy Privacy Week to all of you. My name's Steph Gregor. I manage the Capability and Guidance team here at the Office of the Privacy Commissioner.
Cool. And good everybody, I'm Alex Robertson. I am a compliance officer and I work in the compliance and enforcement team here at the Office of the Privacy Commissioner. And as you may have just heard me alluding to, prior to working at OPC, I used to work for local government for about 5 years with the Wellington City Council's parking services team. So coming at this with a fun mix of privacy and local government experience.
I do not have local government experience, but I have privacy experience. So that's, between us, I'm sure we'll figure it out. So welcome. I'll tell you what we're going to talk about today. So that's coming through. So we're sort of going to tag team what we're talking about. So I'll start by giving us a bit of an overview of the Privacy Act, what the information privacy principles mean, what they all are. Alex is going to give some bit of a talk about what a privacy breach is, how you can avoid it, and also what to do if it actually happens, right? How to notify our office, that kind of stuff. I'll talk a bit about the unique privacy challenges that local government face. And then Alex, you'll talk about power dynamics and the need for transparency. We'll give some time, some more information about how you can find out more information if you've got any further questions. And we hope to have heaps of time for questions at the end. So we've got a Q&A function. Feel free to put them in and we'll look at those at the end. Have you got anything else to say before we kick into it?
No, let's get cracking.
All right. What is the Privacy Act? Who does the Privacy Act regulate? This is the exciting stuff. Okay, so the Privacy Act 2020 regulates what's called agencies. So an agency is any public or private sector agency that collects or holds personal information. Importantly for you guys, local government, you'll all be agencies. District authorities, regional authorities, unitary authorities, district councils, regional councils, all of you are regulated by the Privacy Act. So what the Privacy Act deals with is personal information. So that's information about an identifiable individual. It doesn't have to necessarily be the person's name, but often it is, that's often part of it. But it's also other things that tell you about that person, where they live, what they do. And Alex will get into that a bit more when you're talking about breaches, won't you?
Yeah.
So you're regulated by the Privacy Act. Now I'm going to run through the information privacy principles. So the Privacy Act is what we refer to as a principles-based piece of legislation. There are 13 information privacy principles, or IPPs, that deal with how you collect information, what you do with information, how you can share it, how you got to keep it safe, all that kind of thing. So the whole thing about it being principles-based is that you can apply it to whatever situation that you're dealing with. So I will go through all 13 and I will go through them really quickly, and it's fine if you don't retain them. Okay, the first 4 are about collecting personal information. I'll highlight the ones that I think are key. So IPP 1 is about only collecting the information that you need. So this is about having a purpose for which you're collecting personal information. And the purpose is local authorities will be tied back to what you do as a council. So what the purpose is and if the information is necessary for those purposes. IPP 2 is about getting the information directly from the person where possible. So sort of the fundamental underlying rule is that you get it from the person who it's about, which I suppose, that makes sense. But there are a number of other situations where that might not be possible, that might not be the case, that might not be appropriate. So there's heaps of exceptions in IPP 2 about reasons that you could get it not directly from the person. IPP 3 is about being open what you're doing with personal information. So telling people what you're doing with their information. And so this is where things like privacy statements, privacy notices, all the forms that people are filling in, they're often exercising, dealing with the IPP 3 stuff. One thing that's not up here, but that I will just briefly touch on is IPP 3A, which will be a new privacy principle coming to a Privacy Act near you on the 1st of May 2026. So next year. This is a sort of reverse plug for something I've already done. I've already done a webinar on IPP 3A on Tuesday. So if you're interested in hearing about that, that might be quite useful for you. But that's sort of tied in with the IPP 3 stuff. IPP 4 is about manner of collection. So being fair about how you are collecting personal information. All right. The next 3 are about holding personal information. So these ones, I think these are key. So IPv5, keep the information secure. Don't get hacked if you can help it. Make sure that you're taking reasonable steps to make sure that your information is safe. That includes when you're sharing it, that includes whatever you're doing with it. And again, this is all going to come up in privacy breaches. IPv6 is about letting individuals access their own information. So this is, you might hear it referred to as like a Privacy Act request or an access request or an IPv6 request. They're all talking about the same thing, which is the right in IPv6 for people to ask for a copy of their own personal information, and you've got to give it to them with very few exceptions. Then IPv7 is about information correction. So IPv6 and 7 are sort of like sister principles, because if you don't know the information that an agency has, then how can you ask them to get it, to correct it if it's wrong? So IPv7 allows individuals to ask you to correct the information if it's wrong. As with all of the IPPs, there's a bit more nuance to actually how it goes in, but for the purposes of this, I'm just rushing through them. And then we're on the final dash of what are the IPPs. So IPv8 is the accuracy principle. So make sure that information is accurate before you're using it. Make sure that it's about the right person, that it's saying the right things, those kind of things. IPv9 is about retention. So that's about how long you keep personal information for. You can only retain it as long as you need it, which is usually tied back to IPv1 that I was talking about before, which is like the purpose that you're collecting it for in the first place. This is often coloured by the Public Records Act, particularly for local government. So if the Public Records Act says you need to keep this information for this amount of time, or you've made it a disposal schedule under the Public Records Act, then that essentially sets what your retention period is, and that's how you meet IPv9, is by complying with that. IPv10 is about use. So why can you use the information? You can use it for the reason you got it, is the sort of fundamental thing. And there are a few exceptions to that, like there are in all of the IPPs. IPv11 is mirrors IPv10 quite closely. So it's about why you can share information with other parties or other people or other individuals, whatever it is. So you can only disclose it for the reason it was collected. So again, you're tying back to purpose. It all comes down to your purpose, or a number of exceptions. It also all comes down to. IPv12 is about only sending information overseas if it will be protected. So that's about, it sort of does what it says on the tin. Only share it overseas if you think they can look after it. And IPv13 is about unique identifiers, which I'll leave that there, that those are the IPPs. So from there, I'm going to turn over to our compliance expert, Alex.
Amazing. Felt like I could hear some Eurobeat in the background with that speed run of the IPPs. But anyway, moving on to privacy breaches and some common examples. If we could have the next slide, please. There we are. So just a lot of this will be just getting back to basics, but just to really quickly cover, a privacy breach is essentially when personal information held by an agency or council in this case is accessed, disclosed, altered, lost, or destroyed accidentally without authorization. And then you have notifiable privacy breaches, which is basically that, plus there is a either likelihood or actual evidence that serious harm has occurred. And if a notifiable breach does occur, that triggers some legal obligations around notifying our office, which has to be as soon as practicable after becoming aware that a privacy breach has happened, as well as notifying affected individuals about the breach. And when we say affected individuals, we're referring to the people about whose personal information it is. And there's a part of the Privacy Act, section 117, which lays out some information that those notifications must include. And sometimes it's not exactly clear immediately upon becoming aware that a privacy breach has happened, what actually was all the details. So in meeting those obligations, especially to our office, that information can be provided incrementally. But one thing that is important to note is that when you're notifying both us and affected individuals, you need to have actually confirmed that a privacy breach has happened. Obviously, council will be well aware of getting complaints from the public. So, if you get a complaint that says, you breached my privacy, we expect reasonable investigations to take place, but we'd expect that you actually confirm a privacy breach has happened before notifying us. Next slide, please. Cool. So in working out what a notifiable breach is, a couple of key things to consider: serious harm and sensitive information. Now, serious harm, some examples here, things like emotional harm, and this is where the breach has resulted in or has the likelihood to result in significant humiliation or significant injury to the individual's feelings. Now, obviously, each case will be a bit different, but when we say significant humiliation or individual feeling injury, that's a bit more than being a bit peeved about the breach. It needs to be a little bit more than that. Other examples of serious harm could include financial fraud or theft, physical harm or intimidation, identity theft. And Section 113 of the Privacy Act outlines a bit of a framework for what to assess if you're looking at what serious harm could be. So just to quickly run through what that might look like in Section 113 is you're looking at what have you done to reduce the risk of harm, whether personal information is sensitive information, more on that in just a minute, the nature of harm that could be caused. You're also looking at the recipient of the information. So if it's been accidentally disclosed, for example, what is that recipient likely to cause any harm with that information? Is the personal information protected by a security measure? Now, that could be maybe there's a password protection of a document or encryption, and then just any other relevant matters. And then, so when we're looking at sensitive information, so some elements of information are more inherently sensitive than others. Things like health information, financial information, biometrics, and information about young people. These are things we'd consider inherently sensitive, but context is also key here because sometimes the context can provide that sensitivity. For example, contact details, they're not exactly inherently sensitive by themselves. But if that contact detail were to be sent to someone who might cause harm to the individual, let's say, for example, sending a phone number or an address to someone like a really abusive person, abusive neighbor or a strange partner, that context then provides that sensitivity there. So those are just some things to consider when you're looking at serious harm. Can we have the next slide, please? Thank you very much. Now, so the number of reported privacy breaches is increasing. So I've taken the stats here from December 2020 because that's when the compliance functions came into effect in the update to the Privacy Act in 2020. And from then up until the end of April this year, we have had 189 local government privacy breaches reported to us. Now, 80 of those we assessed as having the likelihood or they did cause serious harm. And interestingly, 45 of those actually related to very basic council functions, things like rates, invoices, submissions. Now, those can be some scary numbers, but it is important to note that having high numbers of reporting isn't in of itself a bad thing. Sure. In fact, we would see regular reporting to us as a good sign of privacy maturity. And also, we like the chance to have a bit of a dialogue with agencies and councils. If you notify us, that gives us the chance to help you with privacy uplift or queries or anything around that. So even if it's a not notifiable breach, we still love to hear from you and have that chance to help where we can. Can we have the next slide, please?
Of course we can.
Brilliant. So some common types of breaches that we see, and whilst these are primarily for council, these are common types of breaches we see across the board. So things like unauthorized accidental sharing or oversharing, and some examples of this is when information has been released, for example, on a council website where elements should have been redacted and unfortunately weren't quite, or perhaps a compliance officer is doing a site visit and accidentally disclosed the contact details of the complainant to the subject of the complaint.
Not ideal.
Email errors, these are one of the most common types of things we see. In fact, 31% of the breaches we've seen from councils are email errors. So these are times where basically, as I kind of alluded to earlier, you've sent information to the wrong recipient. And this could be something as simple as just putting in the wrong email address, or it could be a CC or BCC error, where perhaps you meant to kind of hide the contact details of a group email, but unfortunately put it in the wrong place. And some examples, or a real example we've seen of an email error, is sending a staff's HR details to a member of the public instead of to the HR manager. So, including financial information, it's going to, as we covered earlier, they'll be sensitive, right?
Yeah, absolutely.
Cool. So another example here, just speed running some of the examples, but employee browsing, that's something we see a little bit, and that's basically staff viewing things that are held by the council without a purpose or authorization to do so. So an example of this might be if you're looking up an infringement history of your neighbour just for funsies. Probably not a good idea. And another example of a privacy breach, and we see these ones quite a lot as well, is cyber attacks. And this is basically when a threat actor has gained access to the IT systems and has either accessed and or exfiltrated personal information. And this can usually be due to a successful phishing attack or through IT vulnerabilities. And we've seen things come up before where ratepayers' information, including contact details, addresses, and even bank account details have been accessed by a threat actor by this means. So being aware of some of these is really good. And being aware of them is great. And what are some ways to try and avoid them? So in the example of email errors, really simple safeguards can go a long way. I think we have something here, which is a delay send functionality, or as some of us call it, an outbox jail, where once you hit send, it kind of sits in your outbox for a little bit and gives you a chance to go, oops, perhaps I shouldn't have said that, or did I put the right email address in, and just gives it a little bit of a buffer. But that's only as good as the privacy awareness of the staff member. Obviously, you need to be mindful of what you're doing, checking your email addresses. Perhaps it might be appropriate to look at removing autocomplete from your email and just to mitigate the risk of accidentally putting the wrong email address in, as well as your basic IT security stuff as well. And Cert New Zealand and Own Your Online are really good resources for cyber security stuff. Go ahead, the next slide, please. Now, some of these will be familiar to some of our viewers, but the media love a good story. Councils having a privacy breach unfortunately makes for really good headlines. So this unfortunately draws higher attention to those privacy breaches and can highlight the need to not only have safeguards to prevent them happening, but also highlights the need to follow your notification obligations promptly. And it's much better for affected individuals to hear about these breaches from the agency themselves than other channels, and also better for us to hear about it from the council involved rather from the media as well.
Yeah, and when we say promptly, what do we mean?
So promptly, that will kind of be, it's a general guideline. We have a general guide of about 72 hours, but that's not a hard rule. That's just like a general guide to prompt notification. But again, the exact context and cases will be different depending on what we're dealing with.
Yeah, and you don't have to have full information, right?
Yeah,
to
exactly.
be able to tell us if you only know a few things about it, but you know enough to know that it might be bad. You can let us know those things and keep updating Alex and the team as more comes to light. Absolutely,
and that kind of goes back to what I mentioned earlier about that incremental notifying of us. Yeah.
Yeah.
So we can do the next slide.
Sure. It's me again. Hello, I'm back. I've been here the whole time. All right, I'll talk to you now about common privacy issues faced by local government. There are three key things that I want to talk about, and I might slow it down so I don't get accused of being in a European speed run. So I know I went very quickly through the IPPs. Okay, so here's the first one. So interplay with other legislation, which includes the LGOIMA, and I'll talk at length about the LGOIMA. I know that as city councils, as local authorities, you have a lot of different pieces of legislation that govern the work you do. And sometimes it can be hard to think, well, what one am I dealing with at this particular time? And to think that this particular legislation requires me to do this, but the Privacy Act says that I can only do things for the purpose I collected it, for example. in the Privacy Act, there's a section, which is section 24, which means that if another piece of legislation says that you can or you must do something, then that sort of trumps our legislation. So if a piece of legislation says you've got to share the information for these reasons, or even that you can share the information with these reasons, then that's your lawful authority for sharing it, and you don't actually have to go through that full IPP 11 assessment in the way that you otherwise might. The difficulty is figuring out what law actually applies. And I don't underestimate that burden. And I actually don't have a good answer for how to figure that out. But I guess the thing to keep in mind is that if another piece of legislation says that you have to do something, then you can do it in reliance on that legislation, even though it's not specifically allowed for the Privacy Act, for example. If another piece of legislation is silent on all that, then you do need to rely on the Privacy Act to figure out if you can take the action that you want to take, including, disclosing information or using it for a certain purpose and all those kind of things. I'll talk about LGOIMA now. So this sort of comes to that information request thing. So at a really basic level, there are two ways that people can ask for information from a local authority. So you've got a Privacy Act request, which is the IPP6 thing I was talking about in my speed run before, and a LGOIMA request. So if a person is asking for their own information, that is a Privacy Act request. Even if they frame it as a LGOIMA request, it is a Privacy Act request, and you have to deal with it under the Privacy Act if it's for their own information. If it's for someone else's information, then you're back to LGOIMA. So the timeframes for requests under the Privacy Act and the LGOIMA are the same. They're both 20 working days unless an extension is required, but the withholding grounds are quite different. So for a Privacy Act, there are fewer withholding grounds. There are not that many. So these sit in sections 49 onwards of the Privacy Act, but the presumption in the Privacy Act is that individuals have a right to their own personal information that you hold about them, and so the presumption is that you'll give it to them unless one of the few good reasons applies. Again, this is only about someone asking about their own personal information. So all other requests are processed under the LGOIMA. One thing that I see quite a bit, and which you can't do, so you cannot refuse a LGOIMA request because of the Privacy Act. Because, what do you mean by that? But the LGOIMA does allow you to consider privacy. So it's not enough to say, I'm refusing this because of the Privacy Act, but you can look at section 7.2a of the LGOIMA, which allows you to consider privacy. So that's the withholding ground that relates to the privacy of natural persons, including that of deceased natural persons. So this particular holding ground is just one of many withholding grounds that officers will be able to assess when you're looking at whether to release personal information under a LGOIMA request. So for withholding to be necessary, there must be a reason to believe that the release of the information would affect the privacy of individuals. What does that mean? Great question. There is no requirement for that effect on the individual to be significant or disproportionate or unwarranted, but it just does need to be more than negligible is really the thing there. So the Ombudsman guidance gives us some ideas about how the release of official information may affect the privacy of individuals. So if it would reveal their personal information and in some way intrude on their privacy, for example, by affecting their dignity or their mental well-being, their emotional well-being, by damaging their reputation, or by exposing them to unwanted contact or attention. And I think the example that you gave before, and I know it wasn't a LGOIMA example, but it was a disclosure example about information about where someone lives might sort of be common knowledge for a lot of people, but if that person has a protection order against someone, then actually sharing that information has become suddenly a much bigger issue and has really put that person at risk. So the thing to consider is whether there is personal information in the contents of the LGOIMA request that you're putting out, and if so, figure out how strong that interest is. And so that's sort of the first step. I've got an example here. So if a property manager, for example, makes a request for details of noise control complaints about a particular property, it may not seem on the face of it that that's really that much about personal information. Like the question is, was there a noise complaint about this property or not, I suppose. But even though it's framed as being about this property, it's actually about people. So the property manager knows who lives at this house. So it's personal information about the tenants and potentially also about the complainant. And so this then does become a privacy thing where you should have a think about the privacy of the individuals. But unlike the Privacy Act, LGOIMA disclosures are subject to a public interest test. So under the Privacy Act, that's not a thing. So in the LGOIMA, if 7.2a applies, so if it, would deal with their personal information, then local authorities need to go on to assess the countervailing public interest in the release. So you've got to assess the relative strengths of the privacy interest and the public interest. If the public interest outweighs the privacy interest, then you need to release it. The key thing with this, as with everything with the Privacy Act, is just to make sure you are documenting your reasonings for why you're actually doing something and making it really clear why you're making the decisions that you are. The Ombudsman has some really helpful guidance on the privacy withholding ground that you might find useful. That's the stuff on LGOIMA. The other things that I wanted to talk about is IPv6. So these are access requests. And I particularly want to talk about volume. So when you're getting lots and lots of requests for lots and lots of information, obviously as local authorities, you have so much information from so many different places about individuals, because that's literally your job to have that. And so when lots of people ask for all of their information, then that can be really, really hard. This is anecdotal, but anecdotally, I understand that this is becoming more and more of an issue for local authorities. It can be really burdensome. Lots of people are asking for their personal information, particularly what we call empty your pockets requests. So everything that you have about me. Sometimes people have different reasons for doing this. I understand sometimes sovereign citizens have an interest in doing this. But also people have really genuine reasons that they want to know the personal information that is about them, and they have a right to do that. And so because the right to access information is a really fundamental right that sort of, through the Privacy Act, there aren't that many withholding grounds. There is a withholding ground for vexatious requester, but there isn't, like there is in the LGOIMA, a substantial collation withholding ground. So having said that, often when people are making IPv6 requests, they're actually doing it with quite a specific thing in mind. Often they're just trying to figure out why a decision was made, and they can't really use an IPv6 request to change your decision, but they can ask for some information. The evaluative stuff to the site. And so maybe they are asking for something specific. And if you can work with the individual to figure out actually what it is that they are wanting, and see if they would be willing to narrow the request to find out actually what it is about the information you hold they're particularly interested in. It's not always possible. Sometimes they will just say, just give me it all. And all I can say is that I'm sorry, I know that is a pain. It's sort of how the Privacy Act works. We will keep an eye on volumes. I'm always really happy to hear from you if these are actual issues that are happening and if they are continuing and worsening. But the sort of difficulty is we give guidance, we help people understand the Privacy Act, we enforce the Privacy Act, but we don't make the Privacy Act. And the last thing I'll talk about is about employee browsing. So Alex, you were talking about this a bit before, about people looking at information that they don't have a purpose for. And I think employee browsing, because you have so much information about so many people, and it's also you have information about your neighbours, you have information about famous people that live in your area, for example. You've just got so much information about everything. And it's particularly if you don't have access controls. And if you don't have access controls, then that might be something as an organisation to look at, is actually being able to lock down who can see what, excuse me. But the other thing is just to sort of drill into your own minds and into the minds of the other people who are working with you. You need to know why you are accessing something. That comes back to us talking about with IPv1 with purpose. Like, you need to know the reason that you're doing it, and it needs to be connected to your lawful function. So it needs to be related to your job, basically, and you need the information for that. So then before you go to access a particular system, and I know that often you will have information on 5 different systems, 10 different systems, that you have to get this from here and this from here and this from here, but just make sure you understand why you're collecting it. Just because you have a login for a particular system doesn't mean that you have a purpose to collect the information. You need both. You need the login to get in there, sure, but you also need a reason to be able to get to it. For example, when you're talking about the motor vehicle register, so if you're accessing it, you might be accessing it through CarJam, so you might be accessing the motor vehicle register for certain purposes. You cannot access the register just because you or the person next to you has a login and you know that this particular person's dog is barking too much. Dog control can't use the motor vehicle register for dog control. The motor vehicle register is locked down, it's purpose-based, and those kind of things. So even, systems that have relevant information, you have to make sure that the information you're getting is relevant to what you have. So just keep in the back of your mind, why am I looking at this? And if you can answer that, happy days. Keep on sorting. You're doing well.
Sounds good.
All right, that's me on that.
Amazing.
Oh, this is a link to the Ombudsman guidance that you might find useful. All right, I really sped up through that. I started going a bit slower and then I just rocketed on.
Yeah, that Eurobeat was coming back in at the end there.
What can I say? I love to dance.
Cool. My turn to speak again.
There you go.
Alrighty, so we're going to talk a little bit around the power dynamics and why there's a really important need for being transparent with what you're doing with the personal information you hold. So councils are often positioned in a regulatory capacity, and people cannot always opt out of with providing their personal information or having their personal information used. And this is where that power dynamic exists, where the provision of this personal information or use of this personal information is essentially a compulsory step in a council process. And this could be, for example, building consents under the Resource Management Act. Or in other cases, councils in that regulatory capacity have authority to seek personal information from third parties. And you gave the example for the motor vehicle register, which is authorised by the Land Transport Act. So this places councils in a position where it's really, really important to be completely transparent with what your information you're collecting, why you're collecting it, and what will happen to it, especially if that information will become publicly available as authorised by other legislation. And that kind of comes back to IPP3. Telling people what you're doing with the information. That's actually why IPP3 is my favorite IPP.
Really?
Yeah. Love some transparency. And a really easy way to do that is just having very clear privacy statements. And it's very well and good to have a privacy policy, and I definitely recommend that staff are aware of that. But having privacy statements and having that upfront at the point that you're collecting personal information, just saying to people, hey, your information will be used like this. Like if you're collecting submissions for someone's doing a change to the transport plan and you're seeking public submissions on that, and that if those submissions are going to become publicly available, having a privacy statement upfront that says, hey, just be aware this will be made publicly available. Tell them if you'll redact things or not, and give them the option to say, hey, if you don't want personal information to be made publicly available, please don't put personal information there. And it can be also really helpful as part of that to give individuals providing their personal information a clear contact for within your council of who they can get in touch with if they have questions or if they want to make, as we were touching on earlier, IPP6 requests. Mm-hmm. So sometimes when you're collecting personal information and it's intended to be made publicly available, there are some steps that are really good to take to just being aware if there are other safeguards that need to be taken into consideration. And a clear example of this is the ratings information database, because councils under other legislation are required to make certain ratepayers' information publicly available. And so on one hand, being really transparent about that being the case, I understand there are provisions in that act that require councils to give people both the heads up about that and also give a clear ability to request removal of their personal information from being made publicly available. It can also be useful to proactively think about it a little bit. For example, and this kind of comes back to some of that sensitivity earlier, where perhaps an address isn't inherently sensitive, but perhaps there's context behind the scenes, like an estranged partner lives at that address, and so it's more important to keep that address a bit more secure. That can be something really good to just keep in mind. In fact, we've heard of one example in the past where a council matched ratepayers information that was on the ratings information database with the unpublished electoral roll, which gave a proactive step to kind of just being aware of that and assessing whether or not there was further sensitivity to that that they needed to take into consideration. And I've also seen on some council websites, because obviously you can just kind of plug in an address and see what the rates are for that website. And that's, again, legislatively required, so that's all good. But making sure that contact details aren't immediately Googleable, although they can be requested. I think it's really good to have a big button, as I've seen in some places, where ratepayers can very clearly know, that's where I go to seek that point of contact. So that's really good. And that's just kind of a really good way to just kind of keep in mind safeguards that you need to put in place where personal information is required to be made publicly available. Because a lot of the times, members of the public might not be aware that these other legislations exist. So being upfront about that can also help cut down on complaints as well, which I'm sure every council would like to see less of. So, and again, just those reasonable safeguards, as you're saying, around those access controls as well, making sure that internally people accessing that information have a good job-based purpose to do so.
Totally. Next page.
Yep, next one, please. Now, privacy is for everyone, not just the privacy nerds like us. So having all these kind of access controls and IT safeguards are awesome, but privacy awareness for staff, all staff, is a key feature of doing privacy well, and coming back to our theme about doing privacy on purpose. And we can see this in the examples of some of the breaches we've seen notified to us. We've had everything from breaches involving ratepayers information and LGOIMA issues, or even just to dog infringements and dog registrations.
Yeah, heaps of them, by the looks of it.
Yeah, over 16 breaches that we've seen from that. So, you know, your frontline staff, even those who you might not inherently think, oh, privacy, dogs, not kind of something you'd probably put immediately together, but just highlights the importance that everyone comes into contact with personal information. And it's really important to bake privacy into the processes that staff use as well. So making it easy for those staff to just do privacy well out of the gate. Because I mean, council staff, we're all busy, fully appreciate that. So if you can kind of build systems that support them doing privacy well, that goes a long way.
Absolutely. All right, how to find out more information. And then we'll have about 15 to 20 minutes for questions. So I can see they're coming in thick and fast. So how to find out more information. Lots of different ways. We have e-learning modules on our website that your staff members can do, or you can have as part of induction, about just what are the fundamentals of privacy and how people can make sure that individuals are respecting that. We also have heaps of guidance on our website, and I would say that, wouldn't I? Because it's my team, but it's helpful, it's good, and you might find that there's a lot there that will just make things a bit simpler. We're trying to be quite specific with our guidance so that you can sort of see how it works in your own situations and things like that. Call Alex, send him an email to the compliance thing. He's always happy to chat about compliance issues. I'm always happy to chat about guidance issues. And you'll see the thing I have up on the screen now, which is about Poko Matatapu, doing privacy well. And so this is it's got 10 PO or pillars about key things to do with privacy. What you need to have in place to sort of, like Alex was saying, just bake privacy into the DNA of your organization. You know, make sure that the governance structures around it are good. Your elected officials need to know about privacy. They also, you know, they're a big part of it as well. Know what personal information you actually hold. The security and internal access controls, how to be transparent, IPP3, Alex's favorite IPP. Building capability and awareness. So that's things like, I don't know, sitting in this webinar. Tick.
Yeah.
There's more options for doing it in POPO as well. Breach management, and that's by far our most visited PO out of those ones. So how to avoid a breach, and then if a breach does happen, because sometimes it will happen, how to deal with it and how to minimize the risk, how to manage it as promptly as you can, and how to keep the trust of your ratepayers going forward.
Yeah, and breach management PO also really helps with assessing those things like serious harm or not that we talked about earlier.
Totally. There's also another PO about responding to requests and complaints well. So if you receive a complaint, but individuals can complain to our office, but in the first instance, we'll always send them back to you to make sure that you've done that, so that you can actually sort it out amongst yourselves. And that is way less stressful, both for you, for them. I mean, I suppose for us, if we're not involved, then that's no stress for us, but it's a lot less stressful for the individual and hopefully for your teams if you can actually work things out with the individual. So we've got some flow charts, some examples about how you can deal with complaints well. Assess the risk, measure and monitor what you're doing, and then the 10th PO is called a privacy management plan. And so that essentially brings together the first 9 PO and enables you to say, oh yeah, so this is how we're going with governance, and this is what is missing, this is what we'll do, and then tick, we're going to be all good. And doing that for all of the other things. There's lots of other tools on our website. We've got stuff about privacy impact assessments that you might find useful. We've got a toolkit there. And then the other thing is about finding out who the privacy officer at your organisation is. So there is a requirement in the Privacy Act that all agencies have a privacy officer. So this privacy officer, is in charge of privacy. They might not necessarily be right at the top table, but they often are, and we recommend that they do sit quite high in the organisation, just to be able to sort of have that oversight, or at least maybe report to someone who sits quite high up, so they can help you comply with the information privacy principles, deal with requests made to the organisation under the Privacy Act, work with OPC, and help to ensure the organisation complies with the provisions of the Act. So if you've watched this and you think, oh my God, what am I going to do next? Find out who the privacy officer is. That would be a great first step. And if you are the privacy officer, awesome. Nice job. That's great. Thank you for joining us. Yeah. And well, thanks to everyone for joining us, including privacy officers. There's also the concept of privacy champions is quite a good one that I really like, where you have a privacy champion maybe in every team, in every unit, whatever it is, where people can talk to about privacy, and then they can talk up to the privacy officer. But people sometimes find it a bit less scary if they can just talk to someone in their team about what they're thinking about, and then they go up the chain if needed. But actually, if they can sort it out at that level, then that can often be quite good and a much less stressful way into privacy. Because I think if people think they've done something wrong, they're scared of the consequences and they might hide it, particularly if the only option is to rocket it to the CE.
Yeah, and having a privacy champion, especially in councils, which are typically quite large organisations, having a privacy champion can help with breach management, having someone that you can help speed up the escalation process to that privacy officer, meeting those obligations around your notification to OPC and to affected individuals and getting on top of it. It's just a really good way to help that process along. Yeah,
for sure. And then I guess the last thing I want to say, and then I'll let Alex have the last word, but the last thing I want to say is that I know that you guys have a lot on, that there's a lot going on in local government just across the board. I think sometimes privacy is not as hard as you can build it up in your head to be. If you know why you're doing something, if you know why you're collecting something and how you're looking after it and who you're sharing it with, and if you're writing down the decisions that you're making, that gets you so far of the way there to complying with the Privacy Act. So that's all I have to say. Do you have anything to finish off with?
No, I think we've covered off, and I think people have heard enough of my voice.
Certainly enough of mine as well. Okay. We'll go to questions later. I'll stop sharing my screen so you can see us a bit better. Stop sharing.
Alrighty, let's crack on. And yep, we've got plenty of questions which you'll love to see, and we'll try and get through as many as we can in the next 14 minutes. So,
I've got that first one. Yep.
All right, Steph. When you say overseas, how do external tools play into that? For example, almost all third-party tools are going to have been based overseas. Many agencies will purchase tools and software used with the information stored or processed that weren't created by an agency itself. Or if you could direct this person to a relevant workshop, that would be great.
Thank you, anonymous attendee. I have an answer. The nice thing is, well, the nice thing is, so there's a section in the Privacy Act, which is section 11, which deals with third-party providers specifically. And we've got guidance on it, which is guidance on third-party providers, which is on our website. And so basically the way that section 11 works is that if you are using a third-party provider and they are essentially acting as an agent for you, as in they are not then using the information for their own purposes, then they are treated under section 11 as essentially being you. And so that's not counted as a disclosure. And so the overseas disclosure stuff doesn't come into play. So yeah. So a lot of those tools, that won't be treated as a disclosure if they're not using it for their own purposes. So I'd encourage you to have a look on our guidance for that. And thank you.
Awesome.
Alex,
Yes.
regarding types of breaches, which one is the most common?
So the most common one comes under a fairly big umbrella, which was that unauthorized sharing or accidental disclosure stuff we were talking about before, which was that kind of stuff around accidentally putting unredacted stuff on a website or accidentally divulging stuff verbally. And then, so that was our top category. And then under that, the second most was email errors.
Yeah. People think, I think when they think of privacy, they think, oh, you're hacking. But actually, it's human error.
Yeah.
So much of it, eh?
Oh, yeah. Human error kind of comes up as the most, and which is why having that privacy awareness and processes baked in kind of helps really mitigate that.
Yeah, and you can deal with human error way easier than you can stop hackers hacking.
Amazing.
So there's a question also here that I'll answer about what is the definition of biometric information and of young person. So the biometric information, you might want to have a look at the exposure draft of the biometric privacy processing code. I'm sorry, I forget the exact thing, but the code of practice that that we've got on our website that the Commissioner has recently consulted on whether to create. And so that's got a definition of what biometric information means. The young person thing, so there is no definition in the Privacy Act of what it means by a young person. We do also have some guidance coming up about children and young people. But basically the younger someone is, you know, the more you have to make, well, you have to make sure that you're looking after everyone's privacy, but the more care you have to take about the fairness and the reasonableness when you're dealing with younger people. You know, the younger they are, the more care to take. That's what I see it.
Yep. All right. I'll next one along from anonymous attendee. Privacy excluded in other acts and LIM. Do I have to redact private information from the building information attached to a LIM?
Lynn's the old thing. So I don't have the answer for that. I don't think you do need to redact it because I'm pretty sure the LIM is released under another piece of legislation. So if that other piece of legislation says do it, go for it. That's the section 24 thing that I was talking about. If that didn't answer your question, feel free to send us an email after.
Right. Next one, anonymous attendee says, in the context of a complaint, how can we protect staff discussions, free and frank expression of opinions, when a customer requests everything that was discussed about them? Under LGOIMA, we have the free and frank ground that could potentially be applied. What would be the equivalent under privacy?
Jeez.
It's a really big question and a really good question.
Yeah. I'm just looking up the evaluative material stuff, but the withholding grounds for privacy for an IP6 request sit in, you know, in part 4 of the Privacy Act. And if there is an ability in one of these to, one of the withholding grounds to withhold it, then you wouldn't have to give it to them. But if there isn't, then you have to give it to them. So there isn't that free and frank thing that you have in the LGOIMA there. This is only a half answer. I'm not actually in the you know, the dispute resolution teams. I'm not super hot on the IP6 stuff. We've got guidance on our website on that. How many times can I say that, honestly?
Take a drink every time we say check the website. All right, we've got some really hard-hitting questions here.
Whew, okay.
All right, can you clarify in what context you would need to use section 44(2)(a) of the Privacy Act? This is notification that the agency doesn't hold personal information in a way that enables the information to be readily retrieved. Sorry.
Yeah. So I think with this, some people think, oh, maybe that's just the same as substantial collation. If there's heaps you've got to get, then you don't, you know, then you can rely on that. But that's not the case. So it's more than that. So readily retrievable is about it being really hard to get. So this could be a formatting thing. Could be that it's like incredibly old and in certain archives somewhere. I'm not sure. But then you're sort of coming up against your retention stuff there anyway. So it's a high bar, and there are not that many contexts that that I think you would be using it. And I will not say guidance on our website.
But you just
guidance on our website.
All right. Just to give you a bit of a breather from answering all the questions, I will just jump to what have we got? Shani James, who asks, in a complaint neighbours at war context, how do you balance up the right to privacy against the right of a person to know what is being complained about? I.e., the risk is that it becomes obvious who the complainant is. That's a really good question, and unfortunately one that I'm sure that compliance officers at council are all too familiar with. So unfortunately, I think it'll be almost on a case-by-case basis.
Absolutely.
Obviously, you want to make sure you're not divulging any personal information such as name or contact details about the complainant or the subject of the complaint to either party, because that would be a breach of their privacy. But I think it's in the unfortunate case where sometimes even just telling them that a complaint's been laid, the neighbours at war with each other are likely to just kind of put two and two together in their head. And I'm not sure that's something that you're going to have to balance up on a case-by-case basis. There's not a easy answer to that question, unfortunately. I'm afraid I can't be too much more helpful on that. It will just be depending on the exact context at play. All right.
All right. Okay, there's quite a few questions, probably more questions than we have time for. So if you don't get your question, I'm really sorry. Coming back to that limb question, maybe I misunderstood the first one, if that was actually about information having been redacted in the first instance. So I don't have an answer for that. Okay. Interested in your thoughts on how much privacy training staff should have?
Well, that will vary, I think, quite widely depending on the specific role that the staff member has. I'd probably, call me a privacy nerd, but I'd probably recommend a basic privacy awareness for all staff, especially if they come into contact with personal information as part of their job.
Which almost all of them will.
Yep. But yeah, it will be very dependent on their role. I think sometimes if it's like minimal exposure and work with personal information, it could be sufficient to just make sure you're doing privacy training on your onboarding, and then kind of just regular refreshers, kind of perhaps every few months or so. Engaging in Privacy Week is a really good example of that. But if you're regularly dealing with personal information, it's your bread and butter, probably wouldn't hurt to just kind of go a little bit more in depth with it. Our e-learning tools on our website are really good kind of ideas on, and there's quite a wide range of topics there, but there'd be a good starting point, and they're tailored to different branches of personal information. So yeah, it depends on the specific staff member's role.
It always depends. What is the best way to speak to someone at OPC if we have queries about how to apply the Act in some situations? So it depends on the situation about who you would contact, I think. So the first thing to do is actually just try and figure it out internally. So obviously the responsibility is on agencies to make sure that you are complying with your obligations. And so, you know, go to your privacy officer, go to your legal team if they can help you with that, those kind of things. But we also have an inquiries email address, which goes to our dispute resolution team. That'd be quite helpful if maybe it's a one-on-one question. The compliance, if it's a broader compliance one. And if you don't know where to go, feel free to email guidance@privacy.org.nz, which comes to me and my team. And we can either help you out or send you on to the right person. I recommend emailing rather than calling. It's just sometimes a bit easier to be able to explain actually what you're after.
I'm just going to jump to a bit of a clarification on one of my earlier answers here. Confused about the response about the most common privacy breaches, unauthorized disclosure was said to be the most, and then emails. So that when I was saying unauthorized sharing, unauthorized disclosure, the way we kind of categorize stuff for our kind of purposes of kind of tracking whether or not something's the most or not, unauthorized sharing disclosure is kind of an umbrella term that sure email errors are part of that, but emails are a very specific type of that, whereas unauthorized sharing is kind of an umbrella term that can kind of cover some of those other examples that we've mentioned, such as that stuff on the website. I'm unable to give much more of a clear answer than that, I'm afraid.
All right. Thank you to whoever shared the Ask Us questions. Ask Us is our knowledge base where we have over 600 commonly asked questions, and there's one on readily retrievable, which I'm sure is a lot more articulate and a lot more clear than me bubbling my way through it just now. So please feel free to look at that. I'll leave that there. We're starting to run out of time. Yeah, so I don't know if you can answer about whether there are serious breaches caused by elected members. But I had some more general thoughts. Do you know?
Obviously, we can't give away too much details, but I can say that there have definitely been cases I've seen where, unfortunately, elected members have divulged more information than they should have, and have resulted in a breach being reported to us. So, short answer, unfortunately, yes.
Yeah, and I think elected members are sometimes in a bit of a funny position because like they're a councillor, but also they're someone's neighbour. They go to school with this person's kid, and they're often really enmeshed in their communities in a way that, that is quite specific to local government. And so they can sort of be receiving things that it's like, oh, their mate's telling them something at the pub, and helping them understand and making sure that they're aware that they need to take their own steps also to understand what their obligations are, about how to look after information. Sometimes it's a code of conduct thing as well, as if it says that if you what capacity are you working in when you're doing different things. And so I think that that's something that is a specific thing that elected members do need to pay close attention to.
Anonymous attendee says they love our energy. So thank you to anonymous attendee.
Thank you, anonymous attendee. And you know what? It's 4 o'clock. So there's a couple of questions that we haven't answered, and I'm really sorry that we haven't been able to get to it. If you want to follow up, feel free to email guidance@privacy.org.nz, and I can either direct you to the right place or send it through to Alex if it's more relevant to do that. But I'd just like to thank you all very much for coming.
Indeed, thank you so much. And if you've got any questions, again, feel free to hit up the contact details that Steph just mentioned, and would love to have a chat around privacy and local government.
Yes, thank you everyone. Hope you have a great evening. Bye.